All right, welcome back to another episode of The Unknown. And my name is Michael Volpe. I'm in Chicago, Illinois. That's in Cook County, Illinois, and I write at michaelvolpe.substack.com. Richard Luthmann lives somewhere in Lee County, Florida, which I know is named after Robert E. Lee. It was the 204th birthday of Ulysses S. Grant yesterday, not Robert E. Lee. And he writes at luthmann.substack.com. That's Luthmann. That's substack.com. We wanted to do an update. Last year, we had a guy named Matt Grant on the program. He's a hotshot lawyer who took a sabbatical because he got involved in, well, he didn't get involved. His child custody, I think it's just child custody case, turned sour after he relapsed and fell off the wagon and started drinking again. And then he thought that all kinds of shenanigans were going on the state level, and it involved a lot of people who I knew. For instance, his judge, his name is Bruce Hilton. I know that guy from the Vandenberg case. I did a lot with my former friend Megan Fox on St. Louis County, and both Megan and I, our articles or videos that we did were referenced, including the notorious Zoom conference. All of that was referenced. It created a lot of buzz, his complaint did, but primarily it created a lot of buzz because of his resume, because people thought, here's a really good lawyer who sees it, he gets it, that this is a criminal record. And in fact, let me get this back up. Now, um, you want to explain something about this. All right, so this is the initial complaint. Now, we talked about uh, this initial complaint does a very long introduction that the judge, Josh Devine, who was nominated by President Trump in his first term, I believe. Am I right? Is that right?
Very true.
Yeah. All right. So he was none too
Former
happy.
former solicitor former solicitor general of the state of Missouri. Guy's a good lawyer. Was a
Right.
good lawyer. A good judge.
Right. I think the Solicitor General, and that was what one of the Supreme Court justices was for the Obama administration. I think the Solicitor General goes up in front of the Missouri Supreme Court. So he was a big deal. He's now a district judge. He was very unhappy with the original iteration of this lawsuit. He thought it went, not only did he think it went on and on, but it asked for things that there was no way a judge was going to grant him, like removing the entire circuit that constituted St. Louis County. Matt came up with this brilliant idea by basically suggesting they're all corrupt and in on it, and there's a RICO conspiracy, so you have to remove them. And Judge Devine said, "I don't have the power to do that." So he basically said, "You have a couple of choices: either make this a lot better, explain why this is fine, or," and he was suggesting this without like saying it, maybe just withdraw it altogether and be done with it. And Matt decided to amend his complaint, but we're not looking at the amended complaint. Why aren't we looking at the amended complaint?
There was actually motions on the docket for sealing,
The
and so the very
sealings.
first complaint, yeah,
Mhm.
it came in, but then there was all sorts of things that got sealed. All sorts of dockets and defendants whom Matt sued basically brought sealing motions, and they were granted.
And
So
who brought
I
who
have a big
brought
problem.
was that? I think
Several,
I
I'll
think
tell
you
you right
said
now.
Maya Brody. Am I right?
Brody brought one. Yeah, yeah. It's there's a whole bunch of them that brought it. I'll tell you right now. Hold on. Seal, CAL. Okay. Um, so there's a bunch of sealing motions. Document 33 on the docket was an order that granted Brody's motion to seal and redact the pleadings.
Mm-hmm.
Okay, so that there were, there was all sorts of different points on there. There was never any redacted version filed, so the whole thing got thrown out, got sealed.
Mm-hmm.
They had motions to seal the summonses when they put out the amended complaint. Matt Grant put that one out just to avoid the same issues.
Mm-hmm.
So it became a situation where this case very much, a lot of it is sealed. If you go and try and get the amended complaint, which
Hmm.
is, I believe, document number. I don't even remember what it is. It's in there somewhere. But he filed his amended complaint. You cannot click on the
Hmm.
amended complaint in the PACER in the ECF because it's sealed. You click on it, it says this is a sealed document. So when you go to the opinion that we're going to talk about in a second from Judge Devine, we don't know what he's referring to other than what he refers to in his opinion. We can't put
Uh,
the document in front of us and make our own determination as to the full extent that that what Judge Devine says is right, and that's
right.
a problem.
Well, I think we did see the amended complaint at one point. Now, I wanted to point. This is one of my articles. As you can see, Maya Brody right there. That is the very same Maya Brody that was being sued by Matt Grant. She was involved with a guy named Joel Fritz as his ex-wife's attorney. Joel sued Aaron Zielinski of the Cordell and Cordell law firm. That is a very notorious law firm. He recently won, however, he died under mysterious circumstances. That is a landmark lawsuit. As I said, Judge Hilton. So a lot of the names that are involved in this are notorious. However, the problem is that Matt himself didn't have much of a case. Am I right?
Well, I think you and I brought it up in the very beginning when we interviewed Matt the first time. We said,
Mhm.
Matt, how is this case not going to be viewed as sour grapes by the federal court? Give us
Mhm.
the reasons why it's not going to be sour grapes, number one. And number two, the other big issue, how does this thing get past younger abstention doctrine? How does it get past all the other legal
The
issues
most
that we keep
the
it?
other one that's very important is Stumpy Sparkman. He's suing
Stump,
judges,
yeah,
right?
Stumpy
And
Sparkman.
he, we brought up Ken. Oh my God, I forgot his last name. Ken Gerard. He sued his judge. Now he was alleging that the judges were taking bribes, and even despite that, the federal judge Rebecca Ballmeyer still removed his judges from the case, not the lawyers who he alleges were bribing the judges, because she said, even though you are alleging, and at that point he didn't have to prove it, he only had to allege it, even though you're alleging that they took a bribe, the actual thing that you said they did wrong was these orders, and they have absolute immunity from any order they write. So that's how
Well,
strong Stumpy
it
Sporkman, according to Rebecca
there is
Pallmeyer, who is a judge in the Northern District of Illinois. Hold on.
there's
In
two
Matt
exceptions
Grant's
to the
case, he
stuff.
doesn't even go that far. He just basically says that you all got together and you don't like me and you kept me away from my kids. And I had a huge problem with this because he acknowledges that he fell off the wagon. So you're basically saying because the court refused to, on your schedule, get you back to your custody time, that somehow it's RICO. And I think that's ridiculous.
Yeah, that's the sour grapes aspect.
Mhm.
The Stumpy Sparkman thing. There's a couple of things there. There's a couple of ways around that, and that's really
But
statutory.
not
We file.
were any of those ways used by him?
Well, I'm going to tell you right now what he could have done was
Mhm.
injunctive and declaratory relief can be granted under 28 USC 1983 and 1985. He wasn't going for strictly declaratory and injunctive relief, number one. And number
Mhm.
two, the federal government, the U.S. attorney, is always able to bring actions against the judge for malfeasance or violations of the law. That's
Mhm.
18 USC 241. So the Stumpy Spark is the highest bar I think possible, but there are a couple little ways to get through it. Matt didn't even get anywhere close to getting to
All right,
those
now
standards.
we are looking at Judge Devine's memorandum, the order. And before we get to all the stuff that I agree with, I'm going to take Judge Devine to task because I know a lot about what he is writing here. So, Matt, in support of his claim that there was widespread RICO in the Cook County, the St. Louis County court system, provided a true copy of an email. I know it is because I was the first person to release this email from 2017 in the notorious Vandenberg case, where the same Judge Hilton was presiding, where the uh, where lawyers, I don't remember exactly who was going back and forth, but we're going to get to it. And so the email says, from my perspective, we have the October 13th temporary restraining order date and subsequent trial dates in November. How wedded are you to the trial dates? It is important that get evaluated, and I think they're talking about Caroline Less. She now goes by her maiden name. Since we are buying future litigation. So that is the part of the evidence that he provided that there is widespread RICO. Now, if I was Judge Devine, I would not address this because it's in a separate case. But for some reason, he does. Grant declines to accept that the phrase, quote, buying was meant to convey the risk that certain decisions in a case may lead to future litigation. How does he know what that phrase means? Isn't this conjecture? Isn't this conclusory on the part of Judge Devine?
I don't think that's an appropriate finding at the motion to dismiss phase. I think Judge Devine could have been very easily made that after all of the discovery was completed, but there was no discovery completed in the case.
Well, not only that, but I don't know how much discovery would get into that particular case. It's fortunate that I wrote about this case, and part of it, there was a slew, like a cacophony of inappropriate text messages between Elaine Podlowski, the notorious lawyer / guardian ad litem. I think now she does mediation work primarily because of the things that Megan and I did. And not only Caroline's attorney, but the attorney for the child molesting ex, Mel. And so in one, they're scheming to get Caroline into an evaluation. I'm going to approach the judge next week, let him know who I've called and who will and will not see. That's interesting. Why would the guardian ad litem approach the judge on her own? That seems like an ex parte communication. And as we go along, eventually, I think, is this it? Oh yeah, from my perspective, and here is the email that we have. And then of course, I sent an email to everyone. They didn't respond. I don't think that Judge Devine's analysis of this is correct. I think that it's very likely that they were paying people off to increase the litigation so they could make money. But another problem I had with this is this is not the only time that he refers to buying future litigation.
Fix that, the BUI.
Yeah. See it. Is that it? I thought I saw it more than once. Maybe not.
No, just use the search for buying, BUIING.
Oh yeah. All right. Yeah, and there it is again. Grant uses this unrelated email from a case predating his case to prove that there was a scheme by officials, but he ignores that the expression is a colloquial phrase meant to convey that some litigation will predictably create future litigation. How does he know?
That's not proof, though. You understand, this is the pleading stage, right? Proofs don't come at the pleading stage. Allegations come at the pleading stage. What you do when you evaluate the four corners of a complaint is say that given everything that Matt Grant says, if we take it as true, does he state a cause of action upon which relief can be granted? Does he make a valid legal claim? And by talking about proof, the judge is saying, going to the next step. It's not whether you stated a claim, it's whether the judge believes you actually have a claim. And that's the problem. I think that this is susceptible to appeal on that perspective. He could take this matter, if he wanted to the circuit court and try to get this thing put back and sent to discovery, or at least get a chance to amend, a second time. That's the problem that you have here, is that it looks like the judge is making factual determinations about things in the complaint, and not just, taking the presumption and the assumption that what Matt says is true and sufficient. How you test the allegations is through discovery. And what this
Right.
whole diatribe about buying future litigation in the opinion makes
Mhm.
me, I think it makes you believe that this was wrongly decided.
It makes me believe that this guy knows more about this case, the Vandenberg case, which is one of the worst, where judges, CPS, and in particular Elaine Podlowski with her infamous how does she say it? You weren't there, I wasn't there. Talking about the girl telling her she's being molested. It looks like he knows more about this case than he's letting on. I don't know why he spends so much time talking about this email that was meant for background. The substance of his memorandum, of his decision, is that in your case, you didn't prove anything, that none of your allegations rose to anything. So who cares about this other email? You have to
Yeah.
show enough evidence in RICO, and yet he goes on and on about this email. There it is again. Oh no, that there it's bad. No, he talks about this email way too much for me. And this
Well,
is like Shakespeare. Methinks does protest a bit too much. Because
well,
if Matt's correct that buying future litigation is a form of bribery, then it's evidence that there is systemic RICO through the St. Louis County court system, which I know there is because I investigated for about a year. But um, the rest of the memorandum I agree with, and essentially, Matt, basically, this is what we asked Matt, and it's sour grapes. You didn't like your decision, and you came here. You dressed it up as RICO in an attempt to say this is why it should be in federal court, and it's not RICO. You didn't show anything. So go ahead.
I think that that's right. I think that we spoke to Matt, and I even told him, I'm like, look, fine. Let's say you want to make your case, your
Mhm.
personal case, one of the parts of the pattern of corruption, the RICO, the corrupt organization. You need
Mhm.
like two or three others to show that it's a pattern and it's not just you and you're unhappy with your case. And I
Mhm.
think that to answer your other question about Judge Devine, I think he spent so much time about buying future litigation because that is the only other, non that would establish a pattern. If he had
Mhm.
buying future litigation, he had maybe one or two other smoking gun emails or conversations from other cases in St. Louis, he would have
Right.
had enough to go to discovery. I think
Right.
Judge Devine has to do the work here to show that this is sour grapes, or that's the way he reads this complaint.
Right.
I think
What
you'll
do
agree
you
that there's enough. Yeah, go
Right.
ahead.
What he should have done is taken 1 to 2 paragraphs, maybe three, to include the Zoom conference, because that's where it all starts. 1 or 2 articles by me, 1 or 2 articles by Megan. You can find other people who talked about it. And in 2 paragraphs, talk about how there's a history of abuse, including alleged RICO, like this email buying future litigation, like this Zoom conference where they're talking about fixing cases, and then moved on to his. But look, this is an important paragraph. So we're gonna let me read this paragraph. Grant also fails to logically arrange his complaint. For example, he appears to provide 10 different potential predicate acts for his RICO count, with facts for each sprinkled throughout the preceding 368 pages. But, quote, judges are not like pigs hunting for truffles buried in briefs, and neither are defendants. Complaints must address, quote, specific claims or events in a logical and coherent manner with clear connection to the legal claims asserted. Grant has not done so, and as an attorney who repeatedly touts his legal acumen, he is not entitled to leniency often afforded non-lawyers who file pro se, because Grant incorporated by reference 368 pages of allegations into every claim. The court would have to disentangle his allegations and separate the claims that warrant genuine review from those that do not. The court will not allow Grant to, quote, shift onto the defendant in the court the burden of identifying his genuine claims and determining which of those claims might have legal support. Basically, he just droned on and on threw anything at the wall. Most of it was nonsense, and we're not going to try to figure out what's legitimate. And that it was a long very long and rambling complaint, and he blamed everyone, that Matt Grant, that is, everyone but himself for what he did.
This is, they cite Twombly and Iqbal and some of the classic cases about pleading standards, and I think you're right, Mike. I think that, and I hasten to make the comparison, but I will because it's sexy when we talk about it. But La Cosa Nostra, if you ever read it's a criminal indictment, but they bring in RICO, and that was brought in here by Grant. If you bring in RICO, there's always a history section of an indictment explaining what La Cosa Nostra is. You know, and they go through about 10 or 12 paragraphs in every indictment explaining the history of La Cosa Nostra. It's a criminal organization. Here's how it operates. Here's how it functions. Here's the historical basis. If he would have done something like that in this RICO complaint and said the Missouri family court system is corrupt, and we know this, and here's how, and like you said, bring in Megan, bring in some of the most egregious cases. Put 10 or 15 paragraph historical pattern type thing to a scene setter. The federal government does it every day. You can't deny it with that. So he should have really done that. It would have helped out his Rule 8 issues here, his pleading issues. He didn't do that. And he wasn't specific. It becomes like what we call a shotgun pleading. We talked about that in other cases where he threw it all against the wall.
This really was This was a shotgun pleading. I'm surprised they didn't use that term. Now, here's another paragraph that I think is important, and one of many paragraphs that bring to mind the phrase from Hamlet, "The lady doth protest too much." Grant insists that, quote, "this case does not involve fanciful or untrue allegations." The court disagrees. Based largely on unfavorable court rulings in state courts, several people declining to launch investigations, and an unrelated email taken wildly out of context. Again, he refers to that email. Grant infers a massive RICO enterprise, quote, called the, quote, St. Louis Family Court Corruption Organization that seeks to increase attorney and guardian ad litem fees by intentionally delaying custody and child support matters. It does. I've investigated it, but Grant didn't prove any. Everyone involved in his own child custody case is alleged to be in on the scheme, including the mother of his children and sister. It's highly unlikely that 70 people, including state, are involved in a RICO scheme designed to defraud citizens of their money by prolonging. It is highly unlikely, Judge Devine, but it could happen. Without more than what is alleged here, it is certainly not more than sheer possibility. Grant ignores the obvious alternative explanation that the state court judge had sound reasons to rule against him, and that everybody has ignored his calls for investigations because the calls are baseless. I don't know why they ignored his calls for investigations. They're not necessarily baseless, but to put in that I've reached out to the FBI and everyone else and no one will touch this, that has no legal consequences. And this lawsuit has done a disservice to all of the people screwed over by family court, because look at how Judge Devine is treating the allegations. He's saying they are baseless. Now you have a federal court order that all of these folks who have done so much bad to so many people that they can point to and say, a federal judge found this to be baseless.
Well, this is the most important paragraph in the opinion, I believe, and the most important sentences are two that you just read. The first one is that, and it's really the second. Keep that there. I'm going to read that from there. I'm going to go to the point. I'll go back to that page 10 right there. It says, Grant infers a massive RICO enterprise called the St. Louis Family Court, a corrupt organization that seeks to increase attorney and guardian ad litem fees by intentionally delaying child custody and support matters. Had he spent 10 or 15 paragraphs detailing and unpacking that sentence, or that half of the sentence, then this case I don't think gets dismissed. And I think, Michael, maybe you could be the person to write the journalistic treatment of why this is true, why there is a St. Louis Family Court Corruption Organization that exists to increase attorney and guardian liability fees and intentionally delays child custody matters. That's what you've talked about in your journalism for years. And basically, it's true. Okay. The other part about that was, the fact that the idea that this stuff doesn't exist, right? That this is the part where it has to be proven. And that second clause in that paragraph, Matt Grant's not there to prove anything. Matt Grant is there to make allegations. And it was treated, I feel, by the judge like there was specific proofs that, quote unquote, 70 people couldn't be involved in this type of broad-reaching conspiracy. Yet, in federal court, in criminal cases, we've seen organized crime figures in broader-reaching cases be involved with this. And there are people that are defendants in criminal cases just for receiving stolen goods, right? Just for receiving stolen. They're sitting there and they received it. They didn't even know they received it, but they're part of the organization and they received stolen goods. So you can have a broad-reaching conspiracy of things for improper activity. So that in and of itself isn't availing for me. I think that there's a lot here that hasn't been explained.
Right, and I wrote about this not as a legal document, but the St. Louis courts as a criminal enterprise. We didn't find any proof of bribery. There's a guardian ad litem named Sarah Plebin, and Megan found that she owns an awful lot of boats, which is, some amount of evidence that there's bribery, but certainly not enough to bring into court. We found a lot of evidence of perjury. The way that I would have gone about it is to say that there is a criminal enterprise to prolong litigation through the systemic use of perjury and to show a wide variety of perjury. I don't know if it happened in Matt's case, but that's the way I would prove it. Perjury is a predicate act. The way that they engage in a criminal enterprise is in systemic perjury, that these folks will lie on the stand with impunity, just absolutely lie on the stand with impunity. That's the way I would do it. But
I think you have a wire fraud RICO at that point, right? It's fraud. So you have fraud involving the wires of the United States, right? Meaning that they use the mails or the wires, electronic, cell phones, that type of stuff. You say that there's criminal acts, that there's dishonesty, there's fraud, there's fraudulent filings, there's fraudulent swearing. I think that you make out a prima facie case right there for something, some type of fraud there. I think that you're 100% right. That's why this sits so uneasily with me when I read this complaint, or when I read both the complaint and the opinion on the complaint. It's that the complaint doesn't spell it out, and the opinion glosses over. It's really what you see in family court all the time.
Right. I wanted to point out this might be evidence of the fraud. So in one text message, Caroline's attorney, this is related to that 2017 case where they say buying future litigation. Susie files a motion to have Podlowski removed as a gal, but while this appears tough outwardly, behind the scenes they are telegraphing it to each other. And she goes, sending you a nastygram. And then later, she got it. They basically are telegraphing to each other. I just did it for my client's sake. Don't worry. I'm not really going to push for this. Caroline wants me to think that I'm working hard, but you have nothing to worry about. Is that an example of it? Would that be fraud? If you're filing something that you have no intention of actually trying to get to be executed, is that an example of fraud?
Fraud in the legal sense is an intentional misrepresentation, meaning you know and you intend to put something forward that is not true and you know it not to be true. So that would meet those elements on the face, I would believe. And
look, this same case that Judge Devine keeps saying, you're just misreading it. That I have a huge problem with Judge Devine. And I'm going to make a prediction. This memorandum, one day, it's going to haunt Judge Devine because he downplayed everything that's happening in St. Louis County. And one day it will explode. Everyone will see what was happening. And they're going to go back to this memorandum and talk about how much he downplayed what was happening. And it's going to hurt him a lot. But that's the way I would do it. There's a lot of these kinds of fraudulent filings that you're not meaning to follow through on, a lot of perjury. That's the way I would have shown it. But I don't think necessarily that was happening in Matt's case. The biggest problem I had with Matt's case, as he acknowledged, this all starts when he fell off the wagon. I don't understand why you think that it's fraud and misuse of the court and RICO that you didn't get your kids back as soon as you thought you should. There really is a lot of subjective analysis that a judge takes after you've fallen off the wagon. And he seemed to not want to take responsibility for his role. Last thing, he's running for Congress. You want to talk about that at all?
Oh, we'd love to interview him about that, about the basic, his basic platform. Listen, I don't think he's got a bad platform there. I think that he's running as a Republican. It's a crowded field. There's an incumbent there. There's others. He believes that the Republican Party and other people are trying to move against him. Which knowing politics, I wouldn't be surprised. I would actually be more surprised if they weren't trying to move against him, because they always try to get rid of him.
This is his the website. It does continue. We interviewed the two ladies from Orange County. It does continue the trend that family court, and that's Matt right there, that family court victims are running for different offices. I don't think this is going anywhere. I really feel that what he did was file a lawsuit to give himself publicity.
No, stop. He's a solid candidate compared to some of the other people we've seen. The other people are injured in family court. I don't think anybody else has the credentials that he has. He's an attorney. He's an Eagle Scout. He's a man of faith, a man of family. So I think that he's a very good candidate, on his own merits. It's just I think he has to kind of explain what's going on with the federal court case, because I think if he comes and he pivots and he says, look, I'm appealing the federal court case for these reasons. Here's why the judge is wrong. And there is, Michael Volpe, as you recognize, a terrible conspiracy in the St. Louis family courts, and allow me to explain, and that's one of the reasons why I'm running. But here are the other reasons as well. But family court, the problems with family court are endemic and symbolic of what's happening in our society at large, and that's why I'm going to Washington. And please send me to Washington. I think he can make lemonade out of the lemons, but he needs to actually do the work and let people know how and why.
Right. You can't win strictly on family court because not enough people care about that issue. As far as running for Congress,
they care about faith in the family. They care about truth. They care about good
government. As far as being in Congress, there's a lot he can do. Now, as you know, the biggest fix, as I have said, to fixing family court is the complete elimination of all court appointees on the federal level. If you combine that with the elimination of court appointees, what I'm about to say, I think 80% of all the problems go away. There are several programs you need to sunset. Social Security Title IV, the entirety, B, D, A, E. VAVA, the Violence Against Women Act, and fatherhood.gov, CAPTA and ASFA for CPS. You get rid of that. A lot of the money that's driving this dries up. And so a lot of the money that's driving the confrontations and the perpetual litigation goes away. So there is some things he could do if he got into Congress. And that's what I have said for a long time, as far as what needs to be done on the federal level, is to get rid of some of these really bad programs. All right. Anything you wanted to add?
Just that being a budget hawk in today's day and age of political society is actually starting to get pretty sexy. So if you wanted to pull that in, Mike, I know you read the
I
budget.
wish
You
our
wanted
president was a
to,
budget hawk, but that's another story. Look, this is a setback for family court reform, both in St. Louis County and nationally, but it's not the end. And I'll stick to my prediction. Judge Devine, some of the things you said in this, most of what he said is accurate and good analysis. Some of this stuff, I think you're going to see quotes, one and two sentences out of your order someday when the truth completely comes out about what's happening in St. Louis County. All right, we will be back with another episode.